This is an instructional on how to complete the petition for the state of Colorado. Place the county and the district court in which you wish to file here. Remember that you must file in one of the counties that either of the parties reside in. If they both reside in the same district court, same county, you'll need to be filing in that court. You can find the court address online. Court address goes here. Party information, petitioner, respondent. Remember, if the parties will be filling out this document together or jointly, this person will be named the co-petitioner. If petitioner initiates this action on his or her own, this party will be named the respondent. Contact information goes here. This is crucial that the court has your contact information. Make sure to fill this in every heading of every document that you have filed in full every time you file a document. If an attorney is going to be completing this information or this document for you, they will be filling this information in. Case number, division, courtroom. This information all gets supplied to you by the court after you file the documents. In the heading, make sure you check the appropriate box, whether it's a dissolution of marriage or legal separation. If there are children, check here. Number 1 is similar to the heading. Check whether dissolution of marriage or legal separation. Number 2 states that the marriage is irretrievably broken. In order in Colorado to proceed with dissolution of marriage, legal separation, this must be applicable. Paragraphs 3 and 4 ask for petitioner and co-petitioner or respondent's personal information. Make sure you fill this out even though it is slightly repetitive, as filled out in the case information sheet. This information must be completed every time you complete these forms, whether in the military, full legal name, date of birth, length of residency in Colorado, years, months, current mailing address, and other contact information, email, cell phone, for both petitioner and respondent. Paragraphs 5 and 6, make sure to fill in these: date of marriage, place of marriage, and date the parties separated. This is important information for the court to know. 7, this information tells the court whether or not another child is expected of the relationship. Paragraph 8, this is the information of the children. They want their full names, their present addresses, sex, and date of birth. Remember that for present address, if the children are sharing residences between the two parties, make sure to list both addresses in these boxes here. 9 is helpful for the court to understand whether or not jurisdiction is present for the minor children of the relationship. Make sure to review this box and list all the children. Paragraphs 10, 11, and 12 are notices. Make sure you read this information and understand it. These laws are expected for you to know them, and make sure you know they are aware during the procedure of this entire process. Paragraphs 13 and 14. The court needs to know whether or not the parties or children are participating in any other court matters, and if so, the court needs to be aware of them. Paragraph 15 asks if anyone else has had physical custody of the children and might have claim of right to the children. If so, they might be need to made aware that these proceedings are taking place. Paragraphs 16 and 17. This lets the court know if there are any other human services involvement or any prior protection orders, restraining orders, things of that nature. Make sure you read and understand and fill in the information as requested. Paragraph 18. If anything or any court matter has presented in the past with regards to child support or child support enforcement, please indicate if so and what the case number is. 19 is the request of the petitioner asking the court to enter certain orders. If you're asking orders with regard to the status of the marriage, whether it is to be dissolved or legal separation, you will check this box. If there are issues with regard to parenting time or decision making, then you'll need to check this box regarding best interests of the children. If there is a marriage and one of the parties may be requesting maintenance or spousal support, check this box. If there are issues with regard to child support of the minor children, check this box. If there are issues with regards to property and debts, any asset of the marriage that might need divided between the parties, then you'll need to check this box here. Attorney's fees can be at issue if either party has an attorney, and costs may or may not be appropriate. If either the petitioner or the co-petitioner or respondent need their former name or maiden name restored, they'll need to check this box here and put their maiden name in this box in paragraph 20. The following page provides notice under section 1410.107. This information details the automatic temporary injunction. The automatic temporary injunction is to be followed by both parties and is in place until the final decree is entered. Make sure you go through and understand the law with regards to the automatic temporary injunction. It is in place against both parties throughout the entire pendency of the matter. At the bottom of the page, verification and acknowledgement. For petitioner, make sure you understand the above. Sign and date. Below that will be the place for notary. If petitioner is filing this document on his or her own, they will simply have these documents served on opposing party after completing this section here. If petitioner and co-petitioner decide to file this documentation jointly, then co-petitioner will need to sign and date and also have notarized in this section here. If you have any other questions with regards to this form, please feel free to contact an attorney at Mantia Family Law.